Bar Rules Series. Property.
Ownership. Adverse possession. Adverse possession allows a person in possession of land to obtain valid title. To perfect a claim, the possessor must establish that their possession is continuous, open and notorious, actual, exclusive, hostile, and for the statutory period. If possessed under color of title, the claim is for the whole. Otherwise, the claim is for that portion of land which is occupied. Marketable title. A land sale contract includes an implied condition that the seller will convey marketable title, which is title free from an unreasonable risk of litigation. Equitable conversion. During escrow, the risk of loss to the property falls on the buyer, even though the sale has not yet closed. Deed. Validity. A valid deed requires a signed writing that identifies the parties and the property, with words of intent to transfer. Consideration is not required. Merger. At closing, the contract merges into the deed, and the deed governs the parties' rights and obligations. Delivery. The deed becomes effective upon delivery, which requires intent to transfer and acceptance by the grantee. Recording is not required but perfects the deed against subsequent interests. Deed warranty. Warranties protect the transferee from both present and future encumbrances. General warranties protect against all potential encumbrances. Special warranties only protect against encumbrances created by the seller. A quitclaim deed provides no warranties and merely transfers whatever interest the grantor holds. Recording acts. Under common law, disputes over priority of title to land were determined by the rule of first in time, first in right. Recording acts were established to protect the rights of subsequent purchasers against prior title holders who failed to record their interests. Such unrecorded prior titles are not valid against a good faith purchaser for value, who took without notice and/or recorded first. Depending on whether the jurisdiction is race, notice, or race notice. Notice. Notice can be provided by 1. Actual, 2. Inquiry, 3. Record, constructive method. Actual notice. Actual notice means the purchaser is actually informed of the easement, such as when it is included in the deed or explicitly told to them. Inquiry notice. Inquiry notice arises when a reasonable inspection of the property would have revealed the existence of the easement. Constructive notice. Constructive notice is established when the easement is discoverable through a record search of the property in the grantor-grantee index. Shelter rule. A person who takes from a BFP steps into the shoes of the BFP and prevails against any party the transferor BFP could have prevailed against, even if the transferee had notice of the prior claim. Use. Easement. An easement is a right to use the land of another. It may be express or implied. The burden runs with the land, except BPV, bona fide purchaser for value, who takes without notice. Type of easement. Appurtenant easements benefit a particular parcel of land and require two estates. A dominant estate, the benefited land, and a servient estate, the burdened land. Appurtenant easements are presumed to be perpetual and generally run with the land when the dominant estate is transferred to a new owner. Easements in gross benefit the holder personally for the use of the servient estate and do not involve a dominant estate. Easements in gross are not transferable under common law. However, under modern law, commercial easements in gross are generally transferable. Termination of easement against BFP. When a servient parcel is transferred, an easement runs with the land, and the new owner takes subject to the easement unless they are a bona fide purchaser. If the purchaser can show they took for value and without notice of the easement is terminated. Termination. The easement may be terminated by release, abandonment, or merger. Covenant. A covenant is a promise on how land is used. It is a legal right, the breach of which is remedied by damages. For the burden to run with the land, there must be 1. A writing. 2. Intent to run. 3. A promise that touches and concerns the land. 4. Notice. And 5. Both horizontal and vertical privity. For the benefit to run, no privity is required. Termination. A covenant may be terminated by agreement, abandonment, or changed conditions. Equitable servitude. An equitable servitude is a restriction on how land may be used. It is an equitable right, the breach of which is remedied by injunction. No privity is required for the burden to run. Implied reciprocal servitude. An implied reciprocal servitude arises when a developer intends a common scheme and the buyer has notice. It is enforceable by other lot owners, and the remedy is typically an injunction. Profit. A profit is the right to remove soil, minerals, water, or other products from the land. License. A license is a temporary right to use the land of another. It may be revoked by the servient estate. Nuisance. A private nuisance is the substantial, unreasonable interference with the use and enjoyment of one's land. Landlord, tenant. Type of tenancy. A term of years. Tenancy is for a fixed period. It automatically terminates at the end of that period. A periodic tenancy is a recurrent tenancy for a fixed period. It automatically renews at the end of each period. It may be terminated with written notice. The notice period depends on the length of the tenancy, but for a month-to-month lease, at least 1 month's notice is required. An at-will tenancy is a tenancy without a fixed length. It may be terminated at any time. A tenancy at sufferance is a holdover tenancy when a tenant remains after the expiration of a lease. Constructive eviction. A construction eviction occurs when there is a breach of the implied covenant of quiet enjoyment. The tenant must show that there was a substantial interference with the use and enjoyment of the property, give notice to the landlord, and give a reasonable time to cure. If there is failure to correct, the tenant must vacate within a reasonable time and treat it as an eviction. Implied warranty of habitability. Residential leases must be fit for human habitation. If the premises are not habitable, the tenant has 4 options. 1. Terminate the lease and vacate. 2. Make repairs and deduct from rent. 3. Withhold rent for the fair market value in its current condition. Or 4. Pay rent but sue for damages. Abandonment. When a tenant vacates the premises prior to the end of the lease term, the landlord has 3 options. 1. Accept the surrender and terminate the lease. 2. Relet on behalf of the tenant. 3. Leave vacant and sue for rent, subject to the duty to mitigate damages by making a good faith effort to relet. Assignment. An assignment is the transfer of a tenant's entire remaining interest in a lease. Both the old tenant, privity of contract and estate, and the new tenant, privity of estate, are liable to the landlord for rent. Sublease. A sublease is the transfer of a tenant's partial remaining interest in the lease. The new tenant is only liable to the original tenant, who remains liable to the landlord. Concurrent estates. Joint tenancy with right of survivorship. A joint tenancy is a form of concurrent ownership. 1. In which each co-tenant has an undivided, equal interest in the property and 2. A right of survivorship. A joint tenancy is formed by express intent along with the unities of time, title, interest, and possession. The right of survivorship means that upon the death of one joint tenant, the remaining tenants automatically acquire the deceased tenant's interest. Severance. A joint tenancy is severed when one tenant conveys their interest or mortgages their share. These actions break the unities and result in the creation of a tenancy in common. Lien theory. In most jurisdictions, lien theory, a mortgage is treated as a lien on title and does not sever a joint tenancy. Under lien theory, a joint tenancy is severed only upon foreclosure. In contrast, in minority jurisdictions, title theory, a mortgage is treated as a transfer of title, which does sever a joint tenancy. A deed of trust. A deed of trust is a security device where a trustee holds title for the lender. Upon default, the lender may foreclose through a private or public sale. Tenancy in common. A tenancy in common is a concurrent estate that 1. Has no right of survivorship, 2. Requires only unity of possession, and 3. Allows each interest to be transferable. Rights of co-tenants. Each tenant has an equal right to occupy the whole. They must contribute their proportionate share of operating expenses and necessary repairs, but share in a proportional interest in rents and profits. Future estates. Fee simple absolute. A fee simple absolute is an absolute ownership interest in property that exists in perpetuity. Fee simple determinable. A fee simple determinable is an ownership interest in property that automatically terminates upon the occurrence of an event, using words of time, for so long as the future interest is a possibility of reverter. Fee simple subject to a condition subsequent. A fee simple subject to a condition subsequent is an ownership interest in property that may be terminated upon the occurrence of an event. The future interest is a right of re-entry and must be exercised by the holder. Fee simple subject to executory limitation. A fee simple subject to executory limitation is an ownership interest in property that automatically terminates upon the occurrence of an event. The future interest is the executory interest and is held by a third party, not the grantor. Life estate. A life estate is an ownership interest in property that lasts for the lifetime of the holder. Restraint on alienation. An absolute restraint on alienation is void. The estate remains valid, but the restraining language is disregarded. Rule against perpetuities. The RAP prevents a grantor from creating a future interest that would vest too remotely. A contingent interest must vest, if at all, within 21 years after a life in being at the time the interest is created.